Well, good morning, everyone, and thank you all for joining us. We are going to get started in just a moment. So, thank you for your patience. We're excited about the information to share today, and appreciate you joining. All right. Well, good morning, everyone, and thank you all for joining PCR SBDC as we uncover today from the U.S. Patent and Trademark Office Intellectual Property 101. So, we are so happy that you all joined us today. This is such a critical area for so many small businesses as you guys are creating and building and conjuring new ideas and leveraging old ones as well. And so, we're so happy that you joined us. For those that are new to the SBDC, we're one of a thousand centers across the country. We're PCR is part of the local Southern California LA region, and we are here to help businesses start, grow, and we add survive and succeed because we are all surviving through this pandemic. And so this is our role to be able to assist you. We provide all different types of services, but the biggest one are workshops like these, plus one-on-one advising in the areas of legal, marketing, financial. If any of you are looking for first time PPP loans, for example, we can assist you with that. So we can assist you with a variety of services here. All of our services are free of charge to the attendees. And so it is your wonderful government SBA dollars at work to assist small businesses. And we hope that you will take full advantage of every opportunity that you have to be able to support your business with these free services. So we are excited today. I've covered that. What's the SBDC? I'm so excited to get to the content. There's a lot of it today. And so you guys hold on to your hats, take notes. You are free to put your questions in the chat and our speakers will address some of those. And then also pay attention. There might be a little quiz here or there. So just make sure that you guys are getting as much information as you can. And again, remember that there are 3 sessions scheduled. So this one, next Tuesday, and then the following Tuesday. So it's going to be a great series of Tuesdays that we're able to share a lot of really, really great information with you. Our speakers today, I'm Colette Moore. I'm the director of PCR SBDC. I'm a past business owner as well. I had a staffing franchise for 8 years, and I was also a client of PCR SBDC. I share that I was a good client, I was a bad client. We want to help you all to be really good clients and learn how to use every resource that you have available to you. I'm so happy to be part of this organization to share so that we can help you all to minimize mistakes and optimize opportunities as well. And so we also have today Wayne Stacy, and Wayne is the regional director and Western Regional of the Western Regional U.S. Patent and Trademark Office. He carries out strategic direction under the Secretary of Commerce and responsible for leading the USPTO's Western Regional Office, and he's in San Jose. So prior to joining the USPTO, he was a partner at Baker Botts Intellectual Property Group from 2016 to 2020, and a partner at Cooley, where he practiced law for 16 years. And he has a computer engineering background, and he was involved in a trainer with our advisors, and it was very interesting. Lots of great questions that he had to share. And then we also have Stella Mittelbach, And Stella is actually she's the acting senior librarian in the Science, Technology, and Patent Department at the Central Library in downtown LA, a great resource for all of you guys. She's worked for the LA Public Library for 2016, and when she's not working with independent inventors, which some of you are, and entrepreneurs, which most of you are, to find patent and trademark resources and information, she's working to develop her department's exceptional culinary collection. We need more of that. I don't know, Stella, you know, we have a restaurant academy, so we're going to have to get some help in sharing that for you to come back and share some additional information with us. So with that, we're going to turn it over and get straight to our content today with the USPTO, the United States Patent and Trademark Office. And with that, I'm going to hand it over to Wayne Stacy. Take it away, Wayne.
There we go. Sorry, my fingers are getting slower and slower the more I do Zoom. Well, thank you everyone for your time today. And what I wanted to share with you is really the business side of IP, what it means, but more importantly, what it doesn't mean. So I give you back up a little bit and give you a little piece of my background. Of my 24 years in private practice as a lawyer, probably in excess of 20 of that was spent focusing on emerging companies, startups, venture capital work. And so I got to see the very beginning of a lot of companies. I got to see the end of a lot of companies, a failed end, and I got to see lots of successes. And there are a lot of steps along the way. And IP is one of those steps. And that is, I mean, I say one of those steps because there are a lot of other things that you have to do. And that's what you get from the SBA and the SBDC on advice about financing, management, all of those types of.
Uh-oh, everyone, it looks like we have lost Wayne. So we are going, I'm sure that he will be right back in just
There
a
we
second. Okay. And Wayne, let
go.
me know if you need me to switch over to the presentation. Okay.
Okay, you should have me again.
Okay, got you.
So the point, and again, I apologize for the technical difficulties. The point of all of this is I don't want anybody to walk away thinking I need to spend all of my money on patents or trademarks or copyrights to the detriment of the rest of your business. This is one portion of your business decision, and you always have to keep it in mind. When it's important, it's critically important. But when it's not important, it can be a waste of money. And so as you go through and you think about questions to ask today in the chat, think about that from the business perspective. Because before I'm a lawyer, before I'm a government employee, I think like a business person and want to kind of convey that mentality to everyone else about IP. So we start with what IP is out there and what do you need to know? You know, what questions should you be asking? How about now? Not sure. I apologize, everyone. So what I was saying is there's a tremendous amount of information that's available out there for you on the web if you know what questions to ask. So by the end of this presentation, I'd like to show you what questions to ask and how to receive and digest the information that you're getting. So the number one question, what am I protecting? Don't think about patents, trademarks, copyrights. Ask yourself, what am I trying to protect? Is it my business list or my business plan? Well, that would be a trade secret, but I'm trying to protect my business and all of the customers, those types of things. Do I have a new invention? I came up with a better mousetrap, is the classic law school example. Well, once you know that you want to protect that, then we know we go to patents. But if it's your brand name, I've got a restaurant and everybody loves my restaurant and I want to franchise it so people recognize my name, well, then that becomes something like a trademark. So you have to ask yourself first, what are you looking to protect? And from there, every other answer will flow for you. So the one slide you should take away, and if you pin it to your board for everything, is this one, the overview of intellectual property. I'm not going to read it all to you, but this is the one slide that will tell you everything you need to know or go research. And you can see the first question, what's protected? And that's the most important question, what's protected? So the utility patent, that's the classic patent that you have for the invention, the light bulb, the piece of an automobile engine, those types of things. The second piece is the design patent, which a lot of people overlook and don't talk about it because it just is not quite as well used in the community, but it is incredibly important if you're making 3D type ornamental objects. So these aren't what we call useful inventions, they're ornamental. Sneakers are the classic example of the design patent. They're not an invention in themselves, but the design is what sells them. And you may not recognize that as a Nike shoe or an Adidas shoe, but you know that it's important in terms of that design, and people want to knock it off and steal that design because it's artistic, because it's attractive. You get things like ceiling fans also. That's one of the biggest users of design patents, ceiling fans and lamps. Beyond the basic idea that you need to have blades that spin, well, all of the rest of that is about the design and the aesthetics. Design patents protect those. Copyrights your classic content, song, book, picture, those types of things. Trade secrets are things that you can keep secret and you take efforts to keep secret. These are the classic ones. So it looks like Zoom is going to be angry with me all day long. Um, so the
Wayne,
classic is a
I'm sharing my screen. Hopefully you all can see that. And so you just prompt me and I'll try to keep up. Okay.
perfect. Thank you. Hopefully that'll
All
make
right.
this more stable for me.
Okay.
But the trade secret, the key to the trade secret, it's something that you spend effort to keep away from the public, and the public can't determine what it is themselves. The Coca-Cola formula is key, is a key example. They put pieces of it in the vault, they break it up, and it's not just the formula, it's the process. And no individual knows the entire process. They've got all sorts of security around it. They use criminal law to protect against people that try to steal it. That's a trade secret. It doesn't have to be that extreme, like you put it in a vault, but a business plan can be a trade secret. A customer list can be a trade secret, those types of things. And then one of the most common, trademarks. You see trademarks out there. Trademarks aren't the invention themselves. That's the name you put money into building. And that is about reputation. Now, the difference between all of these is what they protect, and then if you look at the bottom, the duration of protection. The typical patents 20 years, design patents 15 years. Copyright is a long time. It's 70 years plus the life of the author. Those things go for a long time. They're meant to be multi-generational protection for content creators. Trade secret is as long as you can keep it secret, you can protect it. Coca-Cola is the perfect example. They've been running a trade secret a long time, and I think they intend to keep it for a lot longer. And then trademark is as long as you're using the name, and as long as that name conveys meaning. So if you put effort and money into building a brand name, you get to keep it. And that's the classic counterfeit. I mean, why do people try to knock off Nike? Well, because people know the name and it stands for a certain level of quality. So that's the process that's there. You have to renew it every certain number of years, 6 to 10 years, but that's just to make sure you're still using it. They try to clean off the list of available trademarks. So if you're not using it, other people can use that name. So let's, if you wouldn't mind going forward one slide. So the thing that I see in a lot of new people to IP is they start thinking about one piece at a time. Oh, it's a trademark. I'm going to do trademark, or I'm going to just do patents. In a business and a product are actually built upon multiple pieces of IP. Rarely is a single piece of IP useful in itself. So the iPhone is the perfect example because it's got everything in it. First of all, trademark. Well, I just told you, iPhone. When I tell you that, you know it's Apple. It comes with a certain level of quality. It comes with a loyal customer base, or it comes with I guess a group that would be the anti-Apple people. But you know you're getting Apple, or you're going to go get Samsung. Those are brands, and they've spent years building up around the big name, Apple. But then look at the individual product names: iPhone, iPhone X. All of those smaller components are also protectable by trademark. And so that's what you think about in trademark: company name and then individual product names underneath it. Patents, here you go, your class. This is what people would think of when you talk about an iPhone. And I've done this for my law school classes. I ask them, and everybody gravitates toward patents. But ask yourself, what's probably more important, the chemical compound patent or the name Apple? So Apple, I mean, the name carries a lot more value than one particular little innovation in this type of system. But you also see multiple patents. There may be 100 patents for an iPhone over multiple generations of this device. So even within trademarks and patents, it's not necessarily just one trademark or one patent. You start stacking things together to build protection. On top of that, you see copyrights. Well, you've got the traditional software copyright for the code, the instruction manual, which no one ever reads, so that one may not be too valuable. But under that, the ringtone, the content that's going onto the iPhone. Think about the value in iTunes. Think about the value. I mean, what is Apple TV about? It's all about the content, and in that, the copyright's protecting the content. So Apple now has this big ecosystem. Trade secrets. I have to assume that there are some trade secrets, manufacturing processes, things like that, that Apple is using. If I could tell you what they were, they'd no longer be trade secrets and they wouldn't be on this list. So there are things they keep to themselves that might be patentable, but they choose to keep it to themselves because it's not reverse engineerable. Nobody can figure out what it is, so they keep it a secret, and they spend money to keep it a secret. The last one, design patents. Nearly everybody misses the design patent on the iPhone. And this was the huge litigation between Apple and Samsung. So when you look at this, and you can see the main feature, what was the big part of that litigation about? What design was so important? So you can see it in all three of these pictures. Now you don't even recognize it. It's the rounded corners. Instead of the square brick, this rounded format became the real fight, or part of the real fight, between Apple and Samsung on that design. So you look at those rounded corners now, you think iPhone, but that was the design patent on this particular device. Also about the placement of the camera, some things like that. It has no real useful function. It's just pretty, but incredibly powerful in that it led a huge fight. Sometimes the aesthetics make the product. And you can see that in other design patents in the car industry. So, that could be as important as some of the underlying technology. Okay, we can go forward one. So now to give you a little more detail, I want to talk about trademark. You often see this circle R. And one thing about trademark is it's a little more fluid and a little less formal than patents. Patents, there's only one way to go, and that's through the federal government. And if you make a mistake on timing, you lose your patent. Trademark is more about building a brand name and protecting the public and letting the public invest in that name. So there's a lot more flexibility in what happens. There's a federal trademark scheme, and then there are individual state registrations. And you can get away with not registering at all. But I didn't say that was a good idea. I just said you could get away with it and you could build your name. But why is that a bad idea? So we'll talk about that. And there's a really severe catch that hits a lot of people if they don't think about trademarks and about names when they start pushing out products. Next slide, thank you. So what can a trademark be? What can you protect? And the scope of what a trademark can be is tremendous. The end of the day, it's anything that conveys a company or a source of goods. You see Under Armour, just typical letters. You know what that is. But I think most of you are going to recognize the green right underneath that. No words. Girl Scouts. You get a mixed mark that you see McDonald's. So you get the graphic plus the words. You know what that is. But the two of the most famous marks, you've got the apple, which no one confuses anymore. And then my favorite, bottom left-hand corner, officially referred to as Jumping Man. Most people would refer to it as Michael Jordan, but we all know it's Nike. And so words, pictures, whatever conveys origin and manufacturer, and you can invest in building a brand around, works as a trademark. And that's the beauty of trademarks. Go forward one. One more. So the key thing I would like everybody to know about trademark is number two. If you're taking any notes, what gives something the ability to be a trademark? It distinguishes your goods and services from those of another party. It has to be able to distinguish. And this is what the catch out there. People try to use a generic name, and we're going to talk about this in more detail, but they try to use a generic name that doesn't distinguish one from the other. It's the joke you often see on TV. People name their dog dog. Well, that doesn't really help. I mean, it tells you what the animal is, but it doesn't really give it a name. And that's the reason it's often a joke. But sometimes naming your product something very generic helps get it out there, but it doesn't distinguish it from the next person trying to get it out there. So that's the entire key on that front. So let's go forward one slide. So these are the formal names you see. The composite mark was the word plus the image. So often what I talked about, you put multiple trademarks together. Coca-Cola would use all of these. They'd protect the word mark, Coca-Cola, the script, the special form mark, the composite mark. They get multiple trademarks depending upon what image and how they're trying to market their product. You don't have to do it, but this is the path they go down very often to get better brand protection. Again, it's not just Coca-Cola as a brand, it's the trade secret of the manufacturing process, the special shape of the bottle, and the word marks that they've been building up for years, and the pictures. Next one, please. Perfect. And I saw a question about the company logo being your trademark. And the answer is absolutely. If that conveys source, you can use your company logo. And these start becoming some of the more extreme versions of trademarks. The bottle shape for Coca-Cola, that's a trademark. Just that shape of the bottle. You see that, I don't need to read Coca-Cola on it. I know where it came from. The Tiffany blue box, that came around because they invested in that type of branding. And in a live presentation, I'll always do this with the Hershey Kiss. So all Hershey Kisses come with the little tag up top that says Kiss or Kisses. I'll cut that off and I'll ask people what those are. No one misses it. No one says it's a chocolate. Everybody says they're Hershey Kisses. So a piece of chocolate wrapped in silver foil becomes a trademark if you invest in building the brand around it. Now, it didn't start as a trademark. This is the key. It didn't start as a trademark. Over time, people began to associate that shape and that tinfoil wrapping, which now comes, of course, in green and red for the holiday season. They started associating that with Hershey's, not with just random chocolate. So that's how broad a trademark can be. Now you're trying to pick a name. Oh, actually, Claude, that was the perfect next slide. You're getting to read my mind. Wonderful. This is what the strength of the mark. This is what you need to think about. A weak mark is generic, and that means the USPTO is going to push back when you try to register it. You're going to have a lot of trouble. And at the strong end is that kind of fanciful, arbitrary mark that means nothing. You're building a brand name around it. And in between, kind of all different variations. But if you pick the weak mark, you're likely to have a lot more attorney's fees in pushing it through. So we go to the next slide. I'll give you some examples of types of marks from weak to strong. So fanciful. These are marks that at the time had no meaning at all. Xerox. For those of us a certain age, Xerox became a verb. Instead of copying something, you Xeroxed something. That's how famous their mark became. But it meant nothing at the time. Microsoft meant nothing at the time. Cisco, nothing at the time. Those are easy trademarks to get, but they don't really tell the consumer what's going on. You have to build your brand name around it. So that's the issue about a fanciful mark. Arbitrary is just the random selection of a word that doesn't match the product. Apple, BlackBerry, those are great examples. Have nothing to do with the underlying product. They just built a name around that particular phrase. Those are really easy to protect as long as other people aren't using those. You get the suggestive marks. These start beginning to have a little more trouble. Coppertone, Dryfoot, Eveready. Those tell you a little bit about the product, but not everything you need to know. But you may get a lot more fight when you try to protect those marks. The next slide, please. This is where you start getting in trouble. When you start getting to descriptive and generic marks. If I call my dog dog, I'm going to get pushed back. If I brand my milk brand as milk, I'm probably not going to get to keep that. That's just you're not really building a brand name. You're not differentiating from anyone else. Now, that's not to say you can never get something around a generic mark, but it takes a huge investment. And one that I watch now, I'm not speaking to whether it's trademark or not, but you see apartments.com being advertised constantly. And that's beginning to build a brand around that particular generic name. It could not be much more generic than apartments.com. But after millions and millions in advertising dollars, I associate that now with Jeff Goldblum. I just see his face when I hear about apartments.com. That, and I think back to Jurassic Park, the two ties on history for me and him. But the point being that generic is something if you're going to protect, you're going to build over time. You're not going to get to protect up front. And usually takes quite a bit of money and time and publicity to make that work. So the next one. So why register? Well, the obvious reason is if you have a registration, you have the ability to stop other people from using your name. That's a powerful tool to stop knockoffs. And it's also a powerful tool to stop unintentional knockoffs. So everybody thinks about malicious, bad people knocking stuff off for trademark purposes, but that's not the only reason. Sometimes people just start a similar brand around the same time, and it starts confusing consumers. And so you can't build up your name because somebody else is building up something similar. So registration helps fight that and stops any kind of confusion. The other thing it does is it puts a marker out there, because most people are good and they don't want to knock off a competitor's product or use a competitor's name. Vast majority of people are, in my experience. So they'll look at the register, they'll understand what other people are doing, and they'll steer clear of them. So it's really a warning to other people that says, hey, I have chosen this name and I'm going to build my brand around it. I'm not there yet, but I'm starting. And I just got through working with a winery that did what they wanted to. They tried to figure out what name to use. They launched a new brand of wine and just head-on collision with another company that was already using a very similar name. And so this second company had to call back all their bottles of wine, put a new label on them with a new name, and start over. And that's because they didn't do a good enough search, or what they call a clearance search. So when you're starting to name and launch things on a national basis or even statewide, you've got to think about, am I going to run into other people? Because that can get really expensive to rebrand, rename. And it's happened to the biggest companies out there. They've missed things. But very often it happens to small companies that don't do a search and just head-on collision with somebody already doing something very similar. And that's one of the things I will warn you about. Even if you're trying to be a good person, do everything right, if you don't do the search, you could get hit, have to rename your company, have to redo all of the marketing material, pull a product back, slap a new label on it, and start over. So the search is often the most important piece of naming your product and pushing it out there. So with that in mind, as you walk away from trademarks, think about, what am I doing to protect my name? And then what am I doing, or to keep other people from using my name? And then what am I doing to make sure that I can use that name going forward? And the second piece of those is probably one of the biggest issues I see in small companies wasting money unnecessarily. And I saw a couple of questions. I'm going to save a few minutes and come back to those on this and bring them all together for you here at the end. So I think we can move forward one. Trade secret. So I want to keep the trade secret portion a little bit shorter here, but a trade secret is essentially anything that has value that you can keep secret and you make an effort to keep secret. I mean, people often, when I gave an example, I talk about the formula for Coca-Cola. That's a trade secret. But you've got to think more broadly. A lot of business, a lot of your business arrangement, your customer list, those types of things can be trade secrets also. And you just have to go through the idea of protecting them. These are the ideas of computer systems that only let certain people have access. And if somebody steals your well-guarded trade secret, you have remedies and you can get it back. But if somebody steals your unguarded trade secret, that's your problem. It's not a trade secret if you didn't try to protect it. So if Coke put the formula up on the bulletin board and anybody that walked by could take a picture of it, it's not a trade secret. So you're not stealing it. And so that's something you have to really, really think about. But people often ask, are recipes trade secrets? Well, KFC would say yes. Though if I search, I can find the 7 secret herbs and spices. I don't know if they're legitimate or not, but whether that's still a trade secret or not, I don't know for sure. But that was the idea, that 7 secret spices. Sure, that would be a trade secret if you protected it. Any recipe, the entire process could be a trade secret, not just the ingredient list, but the process for putting it together, which is partially what's behind Coke. Again, the existence of it doesn't make it a trade secret. The protection of it and the fact that other people can't undo the information, can't figure it out on their own, makes it a trade secret. One of the places trade secrets are often lost, and it's if you'll look at near the bottom, owner or owner authorized disclosure. Now, think about that for a minute. The most common way I've seen trade secrets lost are through actions of the owner of the trade secret, accidental disclosure. Sometimes you end up talking to venture capitalists, angel investors, and you hand them the trade secret, and there's no specific agreement in place, like a non-disclosure agreement. There are all ways around this, but it is a very dangerous thing to do. If you're handing over something secret, you need to work through why you're doing it and whether you have protection. And if you think it is secret and you want to keep it secret, that's usually when I tell people you should have a lawyer involved if somebody's asking for that information. A lot of times, companies that will talk to you, like I just saw something pop up, most VCs or investors will not sign an NDA. So they won't. They know the problems, they get sued. So what happens? Well, they're usually careful about not asking for the trade secrets. They want to know what the end result is, where you're getting to, but not how you're getting there. So you can break that information up and talk about it in different ways. And so you can still, and I've seen it hundreds of times, you can get the money or you can talk with the investors without giving away trade secrets. And if they need to get down to that level where they want to understand the trade secret, that's when legitimate investors will look at signing an NDA if they're digging that deep into the diligence. But at the high level, they don't want to get in trouble. They don't want to wreck your company. So they shouldn't ask for trade secrets, and you shouldn't offer them. You can tell them what, but just not the how. Again, you can tell them where you're going to get to, but not how you're getting there. So the last bullet is the limit of trade secrets, independent development. If someone comes along and develops that same recipe, if I could figure out tomorrow how to make Coca-Cola, legitimately, I didn't steal anything, I just came up with a recipe, that's Coke's loss, not mine. I can come up with it independently. That's the difference with patents. Patents protect the first inventor or the first person to file the patent application. And then everybody else behind that, even if they're honest, legitimate, did it all themselves, they don't get any protection. And in fact, they can't even make the invention. For trade secret, if you're second, third, fourth, fifth, makes no difference. If you did it independently and honestly, it's yours. So that is one of the limits of trade secret. It's unlimited in time, so it's incredibly powerful that way. But if it can be developed by somebody else, you lose all of your protection. So you just have to kind of make your choices. And for some things, there is no other option besides trade secret, like customer list, business plans, those types of things. That's your only option. But for some of the guts of that iPhone, somebody made a decision, trade secret or patent, and they chose trade secret. Which ones? I don't know. If you did, they wouldn't be trade secrets. I see another question here. Can someone reverse engineer? So two questions there. If they can take your product and reverse engineer it, you lose your trade secret. So anything that can be reverse engineered is not a good candidate for trade secret protection. And so a lot of times, for example, semiconductor chips, those kinds of designs, not great for trade secret protection because people can reverse engineer them. Sometimes they're fine because you're only looking for 12 months of protection, and it takes somebody 12 months to reverse engineer. So there are all these timing issues that you should consider. But if it can be reverse engineered quickly, trade secret's usually a bad choice. Next slide. So copyright is probably the easiest of all to understand. And interestingly,
may I ask a question before you move on from?
Yes, absolutely.
So are trade secrets something to file? Like, is there a filing for trade secrets, or is it just we just call this a trade secret and it is?
Nothing to file.
Yes, and before you answer that, if you all would please put your questions into the chat versus open dialogue, that'd be much appreciated. Go ahead and finish answering that. Thanks.
Yeah. So trade secrets are self-declared trade secrets. And I mean, there's no formal process, but you do not register them with the state, federal government at all. So as for copyright, this is what we all know. It's the content. Movies, music, ringtones, drawings. Doesn't have to be formal. It doesn't have to be good. Copyright doesn't really care. It's the easiest of all areas. As long as it's original, then you can protect it under copyright. So next slide. The word in red is the only limitation. It's got to be fixed in some tangible form. You have to write it down. You have to snap that picture. It can't just be something in your mind. It's got to be, it could be as simple as a sketch on a napkin. Might be the greatest work of art ever. That would be protectable. Nothing else needs to be done. Most of the pictures you take with your iPhone are copyright protected. And I'll give you a classic example, wedding photographs. You know, if you look, wedding photographers protect their photos through copyright. Try going to CVS and putting a wedding photo down on one of their copy machines, and they come out pretty quickly and say, no, 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 you can't do that, because they know the photo may be of me, but the copyright belongs to the person that took the picture. And it could have been digital, it could have been in an old school medium, but the copyright belongs to the person that took the picture. So I buy a copy of, or a print, but I don't have the right to make 50 of them. You know, and that's the same with a recording. I may buy one copy of a movie, but I don't have the right to then make 50 copies of it and distribute them to all my friends. And it's interesting that the wedding photographs are where a lot of people have their first real clash with copyright law, because they cost a lot to get a bunch of prints. It'd be cheaper to buy one and take it to Kinko's and make 50 copies. But copyright protects the business model and the work of the photographer. So next one. Next one. So here's your list. If you think about it, the two that I didn't mention, you know, dramatic works, if you write plays, and choreographic works. So all of that type of artistic expression, if it's reduced to some kind of medium, is protectable. And that's the key. It just has to be reduced. And that's the key. If you look at sound recordings, it's the recording. If I play the music and it's never recorded, it's not protectable. It's not reproducible either. But that's the key in all of these. If you can reduce it to a medium, then it's protected. Okay, next. place where people get in trouble is pre-existing works. So they want to make a derivative, is what it's called, of an existing document or an existing book. They want to write the next chapter. And there's been a lot of litigation around where the lines on this are. And they're a little bit fuzzy about how far you can go. But the gut check you can always say is somebody taking my work, just modifying it a little bit and then trying to make money off of it? Are they trying to make money off of my artistic creation? If the answer is yes, if it feels bad, you probably have an issue to at least look into. On the other side, if it's sometimes some of the most offensive things are people making fun of your work, parodies. Well, parodies are often not copyrighted, or you don't have any protection to stop people from parodies, from making social commentary, for using your work and modifying it to attack a social issue or attack you. Now, those types of things fall under freedom of speech. And I've seen them. I've had clients. It hurts. It stings. It's personal. It's nasty, but it's not something that's prohibited under copyright because of freedom of speech. So often when you think about derivative works and compilations, putting things together, it relates to economic motivations. I'm trying to make a lot of money. Now, those parodies may be making money. That's a different issue. But if they're primarily about social commentary, then you have this protected derivative work. If you want to just look and one of the great parody artists was Weird Al Yankovic, and even he was pretty careful about trying to get agreement from other people to parody their work rather than test the limits of what could happen. And if you read his stories, he did run into some trouble from time to time with people that wouldn't give him permission. But most people did because, interestingly enough, they thought it was an honor because they respected him as an artist. But that kind of parody, he's making money off of it. Would that be protectable or not? Don't know. That would be probably a fight for a lot of lawyers. You get further away where it's clearly social commentary, people can do it. You may not like it, but usually something they can do to you or something you can do. You can use somebody's work to do that kind of social commentary yourself. So next slide. Next slide. So copyright term. The way I usually sum this up, I've been a professor for copyright law. I usually start the class the same way: a long, long time. It's so long you're not going to care. It's with all sorts of strange carve-outs. It's the author's life plus 70 years. The real issue here is it's about creation of like long-term, multi-generational protection. But then you get into corporations and you've got 95 years from publication. Some people refer to it as the Mickey Mouse rule. This has changed over time to make sure that Mickey Mouse is always in copyright protection. But at some point, things do lapse. If you go back to the books my English teacher tortured me with in high school, the Charles Dickens and those types of things, not protectable under copyright anymore. People start making copies of them freely. So you have full right to use classical music from Bach and Beethoven. You have full right to use books from the mid 1800s. At some point, things lapse and we as the public own them and can do anything we want to with them. So next, I think I'll slide forward to patents here. One more. And here we go. So patents. When people talk about IP, they go to patents. This is the place. And this slide is absolutely correct legally. But anytime you hear a lawyer say it's correct legally, there's another shoe that's about to drop. I think it is correct legally, but misleading commercially. And so what does a patent give you? The statute says you have the right to exclude others from making, using, or selling. And people get that in their head. If I get a patent, I can stop everybody else from making my invention. Sure, you can. If you've got the time and the money to invest in a fight. It is expensive. It is brutal often to enforce that exclude right. You basically have to evict people from your technology. It's hard. The vast majority of businesses that I have seen using patents end up doing some kind of commercial deal, some kind of licensing deal. And they end up licensing the patent to a competitor. So there's a couple of people in the market, or they end up trading patents with a competitor. I'll give you access to my technology, but I'd like access to your technology. I developed a really good core piece of the phone, but my interface is terrible. And so we're going to trade. So people often look at patents as I'm going to enforce it, I'm going to sue. They go to the extremes. The vast majority of companies I've seen make money using patents, use them as business tools, as just one more asset they license and trade. And so when you go back and you read this and you search on the internet, people talk about the right to exclude. And that is, I'm telling you, I am a former trial lawyer. I have enforced that right. I know what it costs, and it's usually unpalatable. And you saw that fight between Apple and Samsung, for example. And we're talking $50 million plus in legal fees, just crushing. But most most patents are moved around through commercial deals where people are trading, and then you find 2 or 3 people that are competing in the marketplace and really winning. So it does do a lot of things, great things for you in terms of protection, but you've got to think beyond excluding others. Sometimes that is the right answer, but it is usually not the first answer you need to get to. The other thing about patents that I warn everybody about is there is no such thing as a worldwide patent. If you want protection around the world, I usually tell people you need to own a gold mine. They are expensive because you end up dealing with all of the countries around the world and all of their fees and all of the local lawyers, all the translation fees. It becomes very, very expensive. So people are usually even the biggest companies are very selective. Are there key commercial markets for me to spend my money in? And of all the companies I've worked with and all of the issues I've ever had to clean up, the unnecessary expenses of worldwide patent protection have been one of the main things. I've seen people spend so much money on worldwide patent protection, they didn't get a salesperson, or they didn't do any more R&D, and it crushes them. It's that frightening. So you really have to think about what does it look like to get worldwide protection. There are some options attorneys can show you for kind of delaying the decision making, and you can push kick the can down the road. And those are often very good strategies, but you have to think about them deliberately, and you can't just go in. So if you take anything out of patents that I could share with you, it's that the worldwide patent can crush you. So you be deliberate about what you're doing, protecting the core markets for you. If you're a pharmaceutical company, of course, worldwide makes a lot of difference. But if you're a pharmaceutical company, you're well financed. So it's very different than the average emerging company or startup. So next slide, please. Next slide. And next slide. So when we talk about the two kinds of patents, we talked about, you saw the utility patent and the design patent. Utility patents, your classic patent, there's a lot of discussion out there about it. The thing that there's not a lot of discussion out there, design patents. And these are underutilized. There's some great articles out there when you see what's there. If you Google design patents, you'll find great articles where people are saying, we need to use these more in the United States. Other countries use them a lot. And they're broad in what they'll cover. So these are the sneakers examples. You can see the chairs, all of those. I mean, look, a chair needs a flat surface, or in some chairs, a not so flat surface and something to hold it up. Beyond that, it's all ornamental. So if you come up with a chair design that takes off, well, then you protect it with design patents. The sneaker design, same thing. There may also be some utility patents in there if you have certain things that you had to solve. Like I've got a single post structure and I used a new material to build my chair out of. Okay, I might have a patent on the material, utility patent, but the artistic design, the beauty of it would be a design patent. Design patents tend to be considerably cheaper than a US utility patent. There's some really specific ways they have to be put together. I encourage people to seek out professionals on this to put them together. They are incredibly tricky, but not incredibly time consuming. You just have to know the weirdness of how to represent. You don't get to send in a picture of your finished product. It has to be reduced to a format that the patent offices in the US and around the world want. So you'll need an expert to help, but they're usually considerably cheaper than anything on the utility patent side. So if you're working with industrial designs, any kind of aesthetic design, you should be looking at design patents. If you think people are going to knock you off on Amazon, on eBay, this is the type of protection that might be right for you.
Wayne, you became unmuted or muted.
Okay, next slide. Okay, so the last thing I want to leave you with in patents, then I want to talk about the resources that are available for you. Why get a patent? So a patent is that single tool coming from the US government that gives you, if you're the first to file for the invention, gives you rights over everyone coming after you. So if someone else invents it honestly, someone invents it after spending millions of dollars of their own money in R&D, it doesn't matter. This goes to the person that's first. And the trade is you get the patent because you've then told the world how to build your product. The hope is that somebody else will read your patent and then figure out some improvement. And science moves forward in this kind of cyclical process. You disclose what you did, you get protection for it. Somebody else licenses your patent and then goes further than you did, kind of building on the shoulders of giants. That's been the hallmark of the patent system all along. And that's why it's a more powerful tool than trademarks. So if it's reverse engineerable, you don't have to spend money protecting it. Once you've got the patent, you don't have to keep it secret anymore. So that's why you get that. And no organization other than the federal government can give you that power. There is no state, there's no local authority, nothing else works except the US patent that comes from the US Patent and Trademark Office. And countries around the world, again, have their own centralized system. So there's a German patent office, there's a French patent office. There may be some administrative mechanisms for knocking the fees down to kind of consolidate and share work. But at the end of the day, it goes into those individual countries. So with that, Colette, I'd like to go forward to the map that shows where the regional offices are. and it's probably several down. And while she's doing that, what I want to mention is the United States is different than other countries in the world in that we put a lot of resources into supporting, that's perfect right there, small inventors, emerging companies, and even reduced fees. When we talk with the European Patent Office, they kind of raise an eyebrow about why are you reducing fees for small companies? It's because we want to encourage innovation. And along with that is pushing a lot of resources out there because we all know that lawyers are expensive. Getting good mentors and advice can be tricky. So we want to make sure people have access to resources. We have 5 offices around the country, one in Alexandria, Virginia, Detroit, Denver, Dallas, and then San Jose. But those are just the physical facilities. You can see the color coding here. The teams in those areas actually help across the entire region. So the Western region goes from Arizona to Hawaii for me. And within that, there are partners, which you're going to hear about as the patent or the PTRCs in just a minute. Incredible local resources on that front, but also programs that you can find, and the USPTO's website lays them out. The Inventors Assistance Center, the Patent Pro Bono program is one of my favorites. There are some of the best lawyers in the country that donate time to this, and they're usually administered by nonprofit organizations at the state level. And you can find, again, all those on the USPTO's website, and they can help you put the applications together, design. They can help with trademark issues, copyright issues, and full utility patents. It's an amazing set of resources. A lot of the law schools have partnered with the USPTO to provide clinics that can help file patents, or at least advise you and point you in the right direction. And then the very important piece are these patent and trademark resource centers, which are they're centered in libraries around the country. But the secret to the PTRCs, not that they're libraries. The power of them are the librarians that run those libraries. The knowledge that they have is just unparalleled in terms of giving advice. They can't give legal advice. They're not going to replace a lawyer. But in terms of getting you on the right path, I have been blown away since I've joined the USPTO on the ability of these PTRC librarians around the country to bring resources to their local communities. And we're putting more of them out there all the time. 2 months ago, we launched the first one in Las Vegas to help the small business and emerging company group there. So you're gonna hear from Stella to talk about what resources are available. But what I want you to do, you can't remember all these. Remember the USPTO's website. There's a place there for inventors. Go look at that and find the resources that are there. We've tried to make the website as user friendly as the federal government can make any website user friendly. But the power of a lot of these things put together can at least get you on the right track. You might need an attorney at the end of the day, but hopefully you'll at least know what questions to ask and know how to start blending patents, trademarks, trade secrets with your business strategy. So at the end of the day, again, none of these strategies matter by themselves. They're all part of your larger business plan. And if you don't know how you're going to make money with it, then you haven't asked the right question yet. You got to get to that point first. What do I need this for? And then we can figure out how to make it happen. Don't waste your money on IP that's not going to support your business. And with that, I'd love to give the time to Stella.
Okay. Oh, thank you. That was great, Wayne. So great. So let me just share my screen here. One second. Okay. Can y'all see my slide? So my name is Stella Mittelbach, and I'm a librarian at Los Angeles Public Library in the Science, Technology, and Patents Department. We are a patent and trademark resource center. We were one of the first patent and trademark resource centers in the United States. The Los Angeles Public Library is located in downtown Los Angeles, and my department is on lower level 2 of Central Library on 5th Street. And we are closed for the pandemic, but we may be opening to the public again soon. Right now we're just doing library to go curbside service with books, but we will, hopefully be open to the public again. So what is a Patent and Trademark Resource Center? So the PTRC program is a nationwide network of public, state, and academic libraries that disseminate patent and trademark information to the public. So we're one of over 80 PTRCs in the country, and we provide access to online resources. We have a print collection, and we provide handouts and brochures from the USPTO. So if you have questions, we may have, books that you can check out, like Patent It Yourself, or there's a lot of great books from Nolo Press that we have in the library that you can check out. We have little brochures from the USPTO that we can give you that may answer a lot of your questions. When we're open to the public, we have a couple of computers that are dedicated to people doing patent or trademark searches. And we can answer, a lot of your questions. Of course, we can't offer the advice of an attorney that an attorney would offer. So say you have an invention, you're thinking about patenting it, or you need a copyright form, not sure where to go, or you have a trademark and you want to see what other registered, trademarks there are. Those are the kinds of things that people ask about frequently here at the library. And so if you ever want to get in touch with me, one of the best ways to do it, and I'm going to give you my email address at the end, so feel free to contact me. But we also have this book a librarian service. If you forget who I am or whatever, you can just go to the Los Angeles Public Library website, lapl.org. And on our main homepage, if you scroll down, there's these different topics. If you scroll down from our homepage, there's this Connect with Us section, and there's a link to something called Book a Librarian. So if you ever want to book a session, and I'm doing sessions by Zoom and Google Meet right now instead of in person with people. So if you want to book a session with me, or you have other research questions you have that a librarian could help you with, just go to the Book a Librarian link, and there's a form you can fill out with your information, and me or someone else will get back to you to set up an appointment. And I typically meet with, people 45 minutes or an hour, and I can go over, searching, or I can answer some of your questions. I mean, I can answer a lot of questions or help you find out where to find an answer to your question. We have a research guide, and I'll try and put it in the chat a little later. It's just has a lot of the commonly used links that you might need if you're interested in intellectual property. A lot of the links just go back to the USPTO website. Let's see. Oh, one thing you should know about the library, really neat. This is not necessarily part of the PTRC, but in Los Angeles Public Library at Central Library on lower level 2, on the same floor as my department, we have a wonderful makerspace called the Octavia Lab. So say you wanted to create a prototype of your invention, you might be able to, when we're open again, you might be able to book time on a 3D printer. We have a CNC mill. We have a recording studio. We have a laser cutter. We have sewing and embroidery machines. We have a green screen, and so people have used that to like shoot a commercial for their product. And we also have Adobe Creative Cloud. So when we're open again, if you become a member of the Octavia Lab, you will just need a library card, a Los Angeles Public Library card. And you have to sign, there's an agreement you have to sign just that you'll follow the rules, etc. And then once we're open again, you'll be able to use this wonderful space. So as a PTRC, the things we can help you with are navigating intellectual property resources online and in print at the library. When we're open, we have computers you can use, first come, first serve. We can, print forms from the USPTO and copyright.gov, but you have to tell us which form you want. And we can show you how to perform a patent or trademark search using an example. And that's what we do, by appointment. What we can't offer, we can't give legal advice. Unfortunately, we cannot help fill out forms or applications. We can't tell you which forms you need. We can't perform searches for you or suggest the specific search terms you should use. We cannot interpret government rules and procedures. And we can't advise how to respond to a USPTO office action. One exception to the things we can't do rule. So this probably doesn't apply to y'all that much, but say somebody's doing a historical or genealogical search, like you're looking for your grandfather's patents, that's an exception. If somebody's doing search like that, then I'll help them search for that specific person. So unlike if you have something you want to patent, that's when I don't do the searches for you. So yeah, so just once again, if you have an invention you want to patent, you would want to perform something called the prior art search to make sure your invention is new and non-obvious. And that's something we can show you how to do using an example, looking for U.S. patents and foreign patents and foreign applications and U.S. applications, that kind of thing. If you have something, if you want to trademark your your name or logo, we can show you how to search the USPTO test database to make sure that nothing similar in sound, meaning, or appearance is already federally registered. So once again, we can't tell you exactly how to search. We would show you how to search using examples. And let's see, am I forgetting anything? Oh, so a lot of times I refer people to other, sources of help. So I frequently refer people to the California Inventors Assistance Program if they need pro bono legal assistance for their patent. Also, the UCLA Patent Law Clinic has free help for if you want to, file a patent application. And these are meant for low-income folks, so not everyone, qualifies, but I can, show you those websites. Another neat source of help locally is the organization BetZedek, and I often refer people to them if they want to get a trademark. So yeah, feel free to email me or my department if you have follow-up questions. Also use that Book a Librarian link on our website. And that's, that's about all I had. So I'm going to throw it over to Colette to take over.
All right. And Stella, if you wanted to keep the resource up, and then we're just going to launch a very quick poll, and then we're going to go back to questions, and I'll wrap it up. But you guys are doing great on time. And I see Wayne has been answering a few questions in the chat as well. So please put your questions into the chat. So, first poll, Los Angeles Public Library's makerspace in Central Library is called what? All right. I see you guys.
You guys are
All
doing
right.
great.
Okay. All right. I think you guys were all great, great, great. And thank you guys for
Yeah.
participating in the poll here. We appreciate it. I had never heard of that resource. So, Stella, thank you. All these years, and we have had clients. I know Ventura has a lab that they use, or Ventura SBDC. So, thank you so much. I'm
Yes,
going
the
to share
Octavia
the
Lab is the
result.
right answer.
And yes, and the answer is the Octavia Lab. I did see one question. Is there a cost for the Octavia Lab?
No, it's free to use it. Sometimes there's material costs, like I mean, sometimes like if you need extra filaments or something for the 3D printer, or you want to print a large poster, you can pay for the paper, but it's free to use.
Okay,
As is the
excellent.
PTRC.
Excellent, excellent. All right, let's run the next poll really quickly. All right, and what does PTRC stand for? All of this great help. All right. Thank you guys for engaging today. I just want to know why nobody said patient, tireless, and reasonable. Reasonably, I guess, cooperative. Because you all know you need a lot of patience doing this work. So really appreciate that. All right. All right. And so let's go ahead and end. I'm going to share the results, and you all got that right. The Patent and Trademark Resource Center. So a lot of great resources today to share with you. Thank you all for participating. So I just wanted to mention this, and then we're going to go back to questions really quickly. Is that next week we have the full the rest of the series. So for the next two Tuesdays, so our USPTO group has us for 3 Tuesdays, and we're so excited and them to bring resources in, like the library, the LA library. Who knew all of those resources were available for small businesses? So I don't know if you guys were sitting there. Somebody muted me because I was on the line going, oh wow, ooh, I didn't know some of these resources existed as well. So I hope you guys were taking good notes and you look at the video. The next one is on the patent basics, and then more on trademark basis, what businesses should know now, not later. So we encourage you to take a deeper dive. This was a great kind of overview, and then overview of the resources that you can start, but we will take a deeper dive with patents and trademarks for next week. Then we also have a whole list of other SBDC resource webinars, whether some are launching their business or you're considering these issues now, disaster loan training, PPP, forgiveness, business plan essentials. And Wayne, thank you for sharing that. All of this, it matters if you can make money. So you're not doing any of this work for just the sake of having a patent. You do, or a trademark. It is all about how it goes together with your whole plan for your business. So Wayne, thank you for sharing that, because we, this is not, our role is not hobbyist role here at the Small Business Development Center. So we want people to be sustainable and be able to make money so that they can do with it for generational wealth, or, give it away however they want to, however they choose. New client orientation for any new clients joining. And then we'll be covering the other one. We also, I mentioned, have a restaurant academy, and we're doing business planning, safe, clean kitchens, and business permits as well. So I'm going to open it back up, and let's go through some additional questions. And Wayne, hopefully you've had a chance to take a peek at some of the questions they're raised. And to see if
I have, in one concept I want to make sure everybody always thinks about is who owns this IP. So there are very specific rules around different types of IP. And do you own it? Does an employee own it? Does a contractor own it? And if we go back to thinking about the wedding photographer, people often think I hired the wedding photographer, therefore the photos are mine. I get the negatives, I get the originals, I can do what I want to with them. And that's the classic example because the entire business model is set up around the photographer owning everything because the photographer is the creator of those items. And so as you're thinking about any type of business where you're working with other people, independent contractors, you have to think about who owns the material. I put one link in the chat for copyright, but copyright's very different than patent. And they're all very different based on different parts of the world. So you really have to go through that and look specifically at that particular issue. And I'll give you an example. For patents, the patent can co-belong to the person that helped invent. So if there are 4 inventors, it by default goes to those inventors unless it's changed by contract. So it doesn't matter that you were working for Ford Motor Company. If you didn't have an employment agreement that requires you to assign your patent, you own it, or at least a portion of that patent. So it's really important that you have employment agreements or contractor agreements in place as you start up a company and you're working together. Very often people will hire these independent contractors to come in and do things. Sometimes they'll be in there to write code. Well, that might be, there's some exceptions on ownership. You have to work through it. But then they end up inventing something and then they own the patent that's a huge portion of the valuation of your company. So at the end of the day, you just gave away 20% of your company because you didn't have the right employment agreements in place up front. So I will leave you with that piece. If you're going to build a valuable company, you want to make sure you know who owns the IP because any investor is going to look at it. And you can't assume because I understand copyright, I understand patent. You got to get professional help on that. Documents are out there and available to help guide on that. You can get some pretty nice startup packages, but I've cleaned up lots and lots of messes down the line, and they get nasty because all of a sudden, if you're successful, everybody wants a piece of their money. If you fail, nobody cares. But if you're successful, everything you did wrong is going to come back to haunt you in a hurry.
Wow, thank you for that. So here's a question here. I understand my recipe is a trade secret, but then would the recipe name need to be a trademark?
And I put a couple of comments in on that, and usually names themselves aren't trademarked because they don't indicate source. Now, if it had the name of the restaurant plus the recipe name, maybe something there. But just like the name of a book itself, a single book is not a trademark. That's all under the copyright or trade secret protection. If you had some kind of interesting, fanciful name, maybe copyright, but most of the time, single names just aren't protectable.
Okay. And this is similar on the trademark side. So my logo is my company name. Should I trademark both the name and the logo, even though my logo has my company name already?
It's optional. You definitely can, and people do. If you remember the Coca-Cola slide, Coca-Cola had the words, the fanciful words with the script, and then it had the mark with the image, the logo, and the words in there. So a lot of times you start building layers of IP. So the more you have there, the more protection you're going to have. You just got to figure out, where do you draw the line on the budget? When do you start cutting into sales, other key functions?
Okay. All right. And if I have a business name, yet someone else has the DBA, can I trademark that name?
Those become tricky, but the primary thing to think about is likelihood of confusion. Are consumers going to be confused by these two names? The classic example people talk about, there are 2 huge companies out there named Cisco. And depending who you ask, If I say Cisco to my father, he thinks about a trucking company. If somebody says Cisco to me, I think about the computer networking company. There's no confusion. I've never seen Cisco on the side of a refrigerated truck and thought, oh, there's my next network router. So if you're in different spaces, different fields, a lot of times people will have the same names. But if you're in the same field, the idea of DBA, those types of things don't matter. If you start running into people using the same names, you could have trouble. And that goes with another question that was asked about, can I just search the USPTO's website and know if I can use a name or not? And the practical answer is no, because not everybody gets a federal registration. Some people do state. Some people just register to do business in a state under a name. So those names are floating out there and maybe very, very powerful local brands that don't have federal protection. But if you try to take your brand of wine into their market, you may have a problem in that particular region. So when attorneys do trademark searches or clearance opinions, they tend to look at a broad database. They look at business databases, Dun & Bradstreet, state records about who's registered to do business, federal records, because the names are all over the place. That's the difference between trademarks and patents. Patents are in one place, only one organization's involved. With branding, it's a much broader group.
Okay, great, thank you. And I think that answers Rochelle's question about, are the search tools on government sites sufficient for name searches? And the answer is not fully, because of the state and federal and local jurisdictions. Right.
The short answer, I would say it's better than nothing, but it's that whole thing. It's enough knowledge to just be dangerous and make a really bad mistake. So.
Yeah, and our goal is to help you all minimize mistakes. So that's where these resources come in. So Robin asked, I have a part of my name, the name Da Vinci. A friend of mine said something like that would have a lot of legal suits against using that. And she's wondering, is that Da Vinci name, is that a generic name?
Specific enough, I'm not sure I could answer that one. But in terms of being generic, no, generic is dog. It's just, I named my milk. So Da Vinci could be fanciful and arbitrary if I'm saying my new brand of yogurt is Da Vinci. So it really depends what product you're going on and how you're using it in that way.
Okay. And I think, thank you, Wayne. And I think I think Wayne has answered the question from Norma. How can I trademark a different logo without using a lawyer so it's not too expensive? Because she had already spent $5,000 on trademarking a logo previously.
Lawyer fees are tough. Trademarks, some people manage to do themselves, especially if you have a little bit of a background. There's some great videos on the website, the USPTO's website. And I hear from lots of people where they'll pull up the application form on one side of their computer and then the video on the other side, and it's designed to walk through in parallel. So if you've already got some protection, you may have enough knowledge to go down your own path and run it yourself. The reality is, once you get lawyers involved, they're expensive. They're much more than the USPTO fees. But sometimes when you don't get them involved, cleanup is more expensive than doing it right the first time.
Okay. And how long does it take for a copyright? How long does it take to get a copyright?
So your copyright, the protection actually exists the moment you write it down. The reason you get a federal registration is that gives you the right to sue or protect in federal court. So that makes it puts it in the record so you can then actually enforce it. But the moment you write something down that's original, the moment you take that picture, it has copyright protection. You just have to formally register it if you want to use the legal system to stop people from stealing it.
Wayne, somebody had mentioned the photographer. So question, in the new digital age, with the proliferation of being able to access and people can post online and then that picture is available, has the model, like for photographers and other people that do work for hire, how has that changed with new technology and accessibility?
There's been a lot of writing out there about that. The main issue that's popped up with photography is that it's easier to take someone else's photo and do something with it and copy it and use it.
Mm-hmm.
And it's in many ways become part of the culture. People just say, well, if it's on the internet, I can use it. I can take this photo and I can do anything I want to with it. And that's just not true. Nothing fundamentally has changed about copyright law other than the ease with which we can make copies and distribute them and find source material. But at the end of the day, it's still the same level. That's somebody else's work. And they may not care. They may care. I don't know. You just don't know. But it's their work. And if you're taking it and then reposting it and doing something with it, you may have problems.
Ardina was asking that same question about when a logo is designed by an artist who does it, does the logo design to the artist or the person the logo was designed for? So it's that question of ownership there.
That's all going to be contract law and how you do it. And if you don't know the answer, you need to read further into the deal and work it out. But it's got to be something done beforehand rather than afterwards.
Okay. And I think this is a question, a company in a totally different industry uses the exact same wording of our trademark that our company has. Can we stop them, or is there any legal ground? That's Gene.
And that's that Cisco and Cisco. It just depends on whether there's going to be confusion. They're referred to as classes in trademark world. And the USPTO tries to keep it very narrow. You get a name for your products and what you're doing in your business, and other people can use that same name in their business if there's no overlap. And if it's somebody making beer on one side and tires on the other side, maybe that's just fine. And that comes down to what they call likelihood of confusion.
All right. So you guys, I didn't realize that our hour and a half had already come to a close. We're going to stay on for another 5 to 7 minutes and try to answer additional questions. But I wanted to just regard our time and thank you all for your patience at our start with our technology, got that worked out. So I want to thank Wayne and Sheila for Sheila. I can't see my glasses. Stella, sorry. Wayne Stacy and Stella Middlebach for their presentation today. So much great information. They are an awesome, awesome resource. And I'm so glad that they contacted our SBDC to be able to help as well. We also have someone on their team who has been a great asset to us. Julie has helped coordinate all of this work together and making sure that we have speakers for the next 3 weeks. So we appreciate her. And then also Briagini Sanders, who's our marketing coordinator, making sure you guys can all register and have proper links and get the information and the reminders. And then we'll also make sure that all of those that are registered will be able to get a copy of the today's webinar as well. So I just wanted to do those final thanks to our presenters today. We're going to stay on for 5 or so more minutes. You guys have been putting in great questions. And so we so appreciate our SBDC clients and all of you guys' communication and staying with us through this pandemic to get information. And so I'm going to keep going with that. So let me make sure. Okay. Okay, and Wayne, I think you've answered some along the way, so thank you. Okay, we haven't developed a logo yet. Can we still file a trademark for the name?
Yes. I mean, again, just visualize that Coca-Cola slide. Those are all independently protectable marks. So if you meet all the qualifications, then you can go through and protect any version of that.
Okay. Let me see. if we're trying to file our own trademark instead of paying someone else to do it, if we mess it up, are there penalties, or will someone with the USPTO office help guide the process?
So there are helplines. Again, we're set up to try to help as much as we can. There are some penalties that happen, and not in terms of monetary. It may be that your mark isn't protected correctly, and nobody recognizes that, and that's probably the worst penalty of all, is that it's not protected for you. So there are help desks for you to go through that and put everything together on that front. Again, your biggest risk is if you don't have the clearance search and you run into a problem, that could be an issue for you.
Okay, so not monetary. And Stella, while I'm doing this, someone asked if you could put the slide with the resources back up. And Stella also put in her the website link in there into the chat. And Wayne, I see, put in, as for ownership, a third-party resource for you guys. Let's see. So yeah, Stella, yes, thank you, appreciate it. And then this was another one. Can families, I think you covered that, about the inheritance type work, Wayne.
It's just like a piece of property at that point in time. It's, who owns it, if the company owns it, or if it's passed from inventor, the creator to the next generation. It can all just be set up like a house, essentially.
Okay. And then for using a recipe I found online, many sites have the same recipe. How can I be sure that I'm not infringing on their IP?
Well, depending on what you're doing, if you're just using it to cook at home, that's what they're there for. Now, if you're trying to repackage and put a book together, some kind of compilation of recipes you found off the web, that could be a problem for you. But there is a little bit of practical advice to this. If you're not taking somebody else's work, not trying to monetize it, it's likely that that's not going to really be a problem for you. But if you're building a book, that's when you might get somebody knocking at your door.
Okay. And then someone is mentioning that oh shoot, I'm sorry guys, I got lost in the chat somewhere here. If I had my logo for 15 years, should I trademark or register it? So kind of, is there a limit to like how long before you take that kind of action?
No. I mean, again, it's about helping you build a brand and letting consumers, your customers, know about where it comes from. Very different from patents. Patents has a very strict time limit and you forfeit. But trademarks, no, you don't have those kinds of problems.
Okay. And this was an interesting one. Can historic names be trademarked? For example, names of old ocean liners from the 1900s, not Titanic, which are no longer used.
Possible. There's no express prohibition against it. So you just have to put it in there. That could go into that arbitrary mark like Apple or BlackBerry. Who would have thought naming a phone after fruit? If you wanted to name your beer the Titanic, you might have that opportunity. There's no legal prohibition against it. Maybe somebody else has done it. You'll just have to go through the clearance process.
All right. And then several people copy my business name and model in other cities. They've literally gone to my website and then recreated it elsewhere. I'm looking to franchise. If I trademark my name, what effect will that have on these copycat businesses?
So I think that's a kind of an important one to end with and paint this entire picture. Remember what I said about the phone at the beginning. Remember all the different types of IP that Apple stacked together. And that at the end of the day is going to be your best protection. If you have a business model, something on the website, well, it's not a trade secret anymore, but you need to protect your name, definitely. but there are copyright issues out there about if they're just completely taking your website and recreating it, and they're taking shortcuts. If they're just opening up their own business, then that's on a similar model, then they get to do it. But if they're copying your website, now they've got trademark issues, or not trademark, but copyright issues. So you have to think about some combination of different things or different types of protections for you.
Okay. And with that, we are going to conclude for today. I thank my presenters for staying on. I knew we'd have a lot of questions. I know we didn't get to them all, so you may be able to ask those again next week as well for the relevant topics. And so we look forward to having you all join us. Please tell another small business that might benefit from this information. Let's minimize mistakes, optimize opportunities for all of our small businesses on the call. With that, we thank you all for joining us. Have a wonderful day. Again, thanks Wayne and Stella for joining us and sharing such great resources for you. We really appreciate the time. Have a wonderful day, everybody. And thanks
Thank you, everyone.
PCR SBDC. Have a great day.
Take care.
Bye-bye.